Okie doke. Let's go ahead and get started here. I'm Kyle Farmer, owner of Farmer Enterprises and Farmer Law. I am talk to everyone about the new rule that the DOL finalized, which is called the Farmworker Protection Final Rule. There's a lot of changes in this one, so if it gets to going too long, then we'll maybe have to set up a second webinar, but I think I'll probably be able to get through all of it. We'll find out. Just to give people some background on what this rule is, this rule did a lot of things, and it's changed the nature of filings of enforcement, and there's some real concerns with it. Right now there was an injunction sought against it. So there's a lawsuit by a bunch of states for this particular case. They were supposed to have a hearing for a preliminary injunction on August 2nd, but they agreed to delay that with the Department of Labor, and the Department of Labor agreed that it won't enforce this rule until August 29th as a result of that litigation. So as of right now, this thing is set to be enforced starting August 29th, so about 6 weeks from now. And we'll certainly keep everyone updated on the progression of it. But let's go ahead and get started here. If you have questions, just put them in the Q&A. I'm sure there's going to be a lot of questions on this one because there's a lot to it. The people that I think are most impacted by this are farm labor contractors. Everyone's impacted by it if you use the H-2A program, but particularly farm labor contractors. There's a lot in this rule that's already the law or already the practice of the DOL. It's just codified in the final rule, and they do that for appeal purposes, which they also changed the nature of appeals as well in this final rule, which I'm not even going to really talk too much about. But historically, whenever you file for an appeal on H-2As, you don't do it by telling them and raising all of your objections with the rationale for your appeal at the onset. But this final rule is trying to make it where you do have to do that. Anyways, that's a me problem, not a you problem, so not a big deal. But let's get started here. I'm only going to have this up for a second because I'm about to open up an Excel sheet to show you something, but this is the H-2A regulations update 2024 Farm Worker Protection Final Rule. If you Google that, it'll take you to a screen that actually shows you, or to a DOL website, where if you want to read the whole thing, which doesn't sound fun at all, but in fact, it wasn't fun, but we got to do what we got to do here. All right. So just to kind of summarize, just at a glance, that they were trying to add a whole lot of protections for worker self-advocacy. There's a lot of stuff in here that you couldn't do already, but there's new consequences to it, which we'll get to here in just a little bit. It clarifies when a termination is for cause. So this, we'll get into that as well. Supposedly makes wages more predictable for workers in the H-2A program, enhances the foreign labor recruitment transparency and related form changes. We'll get into all this stuff in detail, but improves protections for workers in the event of minor delay to start of work, which will impact filings significantly for you guys. Improves worker safety, particularly as it relates to transportation. There's just some transportation modifications. Frankly, I don't think that that'll make much of a difference for most people. There's I can think of a few people that it would, but for most people, it won't be any kind of difference. But collects information about the owners, operators, managers, and supervisors. For you farm labor contractors, that's going to be the biggest one. Oh, and by the way, this webinar is going to be focused on H-2A regulations, which are for agricultural employers. So, you know, if you're someone that uses H-2B or something else and you're not looking to get into H-2A, you don't have to sit around for this. But I think almost everyone on here is H-2A. So I just saw some people on the registration that weren't, so I just figure I'll save them the hour and they can get back to work. But it codifies the single employer test, which the DOL already uses, and they really shouldn't be using. There's inconsistency in terms of the ALJ's determination on if that's appropriate or not, but they codified it in here so they can continue to do that. Streamlines debarment processes for successors of interest. That one doesn't happen very often, but we can talk a little bit about that. Rectifies the disclosure of minimum productivity standards. So this is going to require a lot more on your ETA 790, which we'll get into. Codifies the prohibition of passport withholding. I always tell clients don't do that anyways, but now it's not only a potential criminal violation, but it's also an H-2A specific violation. Prohibits side agreements between employers and workers. I've never actually seen that one be an issue before, but it codifies that in here as well. Okay, so I'm actually going to start off with the immediate effective date for updating the adverse effective wage rate. What they were doing historically is they would release the AWR and then they would make it a final rule that the new AWR goes into effect. Oftentimes it was in January. We all know that they changed the wage rate methodology last year for folks that are not in the big 6 categories. But this just makes it to where the wage rates change instead of being given a notice period immediately upon publication. So employers will start paying the AWR immediately. If the AWR is updated in the middle of the pay period, you can defer the payment until the end of the next pay period, but you must provide retroactive pay. So if it happens in the middle of the pay period, you don't have to pay it on that check. You can pay it on the next check, but it has to include the actual difference in wage rate still. So in all reality, it's probably easier just to update it in the middle of the pay period. Retroactive pay is required for all hours worked and ensures workers are paid the updated AWR immediately. Now, great. Okay. You would think that's easy enough. But the problem is, let me show you something real quick, which is wild to me. So the way that you determine the AWR, if you are in a non-range occupation, so we see this oftentimes with truck driving, we see it with construction occupations, all that sort of thing. The way that you normally do that, you go to the government's website to see what the wage is. And it's on flag. We have the URL on the PowerPoint, which we'll send out at the end here. And so you would think like, okay, simple enough. I get on there, I see what the wage rate is. So but whenever you get on there right now, this is the first year that this has been effective. The government gives you 2 options for navigating the proper wage rate. And there's already inconsistency in this. And I'm going to show you this. So I downloaded both of these spreadsheets I downloaded today from the government's website. And you will notice on this one, on this spreadsheet, which is, if you go to that website, you scroll down under Roman numeral 3, it gives you the option just to download this website here. And I filtered for Iowa construction laborers, and it says that the hourly mean is $21.51, which is what it was at the beginning of the year. Now, if you go to the other website, the BLS website, which it also points you to, and you look at the average hourly mean, it says that it's $22.46. So on the DOL's website, even now, it's inconsistent. And so the question is, okay, well, which one do I pay? Well, technically the right one's this one, but they have a mistake. And so what a lot of employers are going to end up doing is they're going to look at the Excel sheet that's much easier to download than to navigate the other one, and they're going to be paying the old AWR. And that's not technically wrong because it is the one published on their website. So I think that with a lot of these things, the government's ability to enforce it and to actually put it into practice is significantly more difficult than they give it credit for, as demonstrated by the first year that they have now published this data, and it's inconsistent. So at least inconsistent for now. I imagine at some point they're going to update it, but okay, let's go back to the PowerPoint here. Okay, so the next part of it is the worker voice and empowerment portion. It strengthens the worker rights to advocate without facing fear of employer retaliation. So what they said in the final rule, actually, I'll just go through these real quick. Expansion of 20 CFR 655 135H to safeguard activities against intimidation, threats, or retaliation. These things are already illegal. You already can't intimidate, threaten, or retaliate against employees that are just seeking to enforce their rights. But it now includes collective action protections and rights to ignore employer speech on protected activities without fear of retaliation, allows FLSA agricultural workers to designate their representatives during certain interviews. Workers can now invite or accept a guest into housing. So this is actually an important one, because a lot of employers will restrict the guest access to their housing because it ends up causing problems. Not maybe whether it's with the person that invited them or not, they'll restrict the amount of guests that can, or the guest policy within their housing, just because it causes issues and it causes damage to their property. And so you can only now put reasonable restrictions. And so what I suggest with the guest policy, and I'm going to circle back to what are these safeguards, but what I suggest with your guest policy is that this is something that you now incorporate into your ETA 790. And whenever you incorporate it into your ETA 790 and the Office of Foreign Labor Certification certifies it, that's the best way to ensure that they are reasonable restrictions. So what I would suggest is that some of your restrictions will include hours. So they can have guests, but they can't have guests beyond this time of day, that sort of thing. The rule does not require H2A employers to recognize labor unions or to engage in collective bargaining, and then employers must not discriminate against workers engaged in self-organization. So let's circle back though to what are these safeguards, because this is important. So the safeguards are what the final rule said is that they had conclusive evidence from some state workforce agencies of employers on video engaging in threatening, intimidation, or retaliatory behavior with the workers for trying to enforce their worker rights. And what they're now requiring is that the state workforce agency not only report that to the DOL, but to stop servicing the employer even prior to debarment. And what this will effectively do is debar employers even without proper debarment proceedings. Because if you can't get your ETA 790 certified by the state workforce agency, you cannot get your 9142A certified by the Department of Labor. And so the state workforce agencies will just say, we have evidence of this, employer hasn't been denied, but we are no longer servicing that employer. Historically, they have not been able to do that, but this rule is allowing them to do so. So that is that's an important one, to be very careful about that. So it also requires a clarification on the termination for cause. Adopts the termination for cause definition in the final rule, and it modified the criteria to justify the disciplinary and termination processes. Ensures the termination and disciplinary actions are justified and reasonable. So protection against unjust termination aims to prevent. So I'm not going to just read this. You can read it. The proper process for ensuring that your rationale and methodology for termination, what I suggest that you do is that you thoroughly go through your ETA 790, your job order, and you go through the processes that would be required for terminating someone for cause, and then you abide by those processes. Now, there's certain ways that you can terminate workers for cause with egregious violations. It even says that in the final rule. It doesn't define what an egregious violation is, which is part of the problem. That now one of the things that I oftentimes see with the Department of Labor is that certain terms are not clearly defined, and whenever they're not clearly defined, that is an opening for litigation. So let's say that you're an employer and your workers did something that you perceive as an egregious violation. I don't know, maybe they violated some safety standard, and you terminated the workers for violating the safety standard. You didn't give them a warning. You did not write down the progressive disciplinary action, which is what it requires, because to you, this was an egregious violation. After all, they could have hurt themselves. They could have hurt someone else. And so you perceive this as an egregious violation. And the worker reports the termination to the Department of Labor, and the Department of Labor says, that's not egregious. Well, then they would say, one, that they could potentially make an argument that you are engaged in retaliatory behavior. They could make an argument that you owe back wages to that particular worker, even though that you terminated them, and it incentivizes the worker to do these things. And so I think that it's very, very important that you go through your ETA 790 and you clearly define what is an egregious violation. What are the things that I'm telling the Department of Labor now? This is an egregious violation in our business, and this is why. And then for non-egregious violations, so for things like production standards, you have a very clearly defined rationale for these are the processes I'm going to take people through to terminate them. And then you need to actually do those and document them every time. And so, which is the whole goal of DOL here. So here are the 5 conditions. These I actually will read for termination for cause. Okay. The worker has been informed of the policy, rule, or performance expectation. So this one, I think, is where the value in disclosing it so clearly in the ETA 790 plays a role, because you can check this box by putting it on your ETA 790, which all workers should sign prior to coming into the United States. It should be translated into a language that they understand, and they should all execute it before they ever enter the United States. So you could say they've been informed because they reviewed the ETA 790 and executed it in their home country. Compliance with the rule, with the policy, rule, or performance expectations within the worker's control. So you can't have any kind of performance expectations that the workers are not able to do because they can't control it. So, you know, if you're performing construction activities and you say part of your job is to make sure that you're on the job engaged in productive employment for 5 days a week, but that may not be within the worker's control because maybe the job's delayed, maybe there's rain or sleet or snow or something like that that keeps the worker from engaging in the work. So you can't have anything that's outside of the worker's control. The policy, rule, or performance expectation is reasonable and applied consistently. So this is the big one. The reasonable part, I think, that you can achieve by disclosing it in the ETA 790. The applied consistently part is a part that I could easily see the Department of Labor in enforcement actions trying to show that the employer didn't engage in applying this rule consistently. Maybe you have someone that's been with you for 20 years, and maybe that person doesn't do things like all of your other workers, but you put up with it because you've known this person for 20 years. Well, you have to apply it consistently, because you don't want the worker to be able to say, well, I did this, sure, but so did he, and they didn't hold him to this standard, because then they'll say that he wasn't terminated for cause. The employer undertakes a fair and objective investigation into the job performance or misconduct. Basically, this is again a relatively ambiguous one, because DOL could say that you weren't fair and objective in your investigation. You basically just took so-and-so's word for it, and that person has it out for this person. You didn't ever do any actual investigation into the job performance or misconduct. And then the employer corrects the worker's performance or behavior using progressive discipline unless the worker is engaged in egregious misconduct. So again, define egregious misconduct. And then the progressive discipline, this just means that you're trying to work towards them being able to stay. Okay, so this one also is going to impact people significantly. There's a lot of times people will talk to me about, okay, well, I've got this certification, but I don't want to bring in all the workers right away. Well, there's already been a prohibition against staggered entry. This is kind of codifying it and applying it a new way. And it also gives some wage implications to how an employer is supposed to notify workers or compensate workers whenever they do have a job start delay. And if you have a job start delay that's beyond 14 days, it has a significant impact on your filing processes. So I'll just read it. If you have a certified H-2A application but need to delay to start work by up to 14 days due to circumstances that could not have been foreseen, the crops or the commodities will be in jeopardy prior to the expiration of the additional recruitment period. You must notify the state workforce agency and each worker you intend to employ on the job order associated with the application of the delay at least 10 business days before the original start date. So you have to identify the workers. You have to tell the workers, hey, we had a start date of April 15th on this. It's now April 4th or maybe April 1st, because it is business days, 10 business days. And we're expecting to delay the start date because of unforeseen circumstances. Now, this is the big part. This is the thing that changes a lot. If you do not provide timely notice to a worker, you must compensate the worker at the required rate included in the job order for each hour of offered work schedule in the job order up to 14 calendar days. So on your ETA 790, it says the number of hours that you expect the workers to work by day. You would use that to determine the number of business days. So say you have 6 days of hours offered on your job order. That would be 6 of the business days, and then the one that has 0 would not count. And so then you'd have to go back to the following week and then 4 of those business days. And then you would look at the hours offered on the job. So say that you have 8 hours Monday through Friday, 5 on Saturday. Well, if you didn't provide the necessary notice to a worker, then you'd have to pay that worker as if they worked those hours up to 14 calendar days. So that's a big deal, because it opens up the scope for potential back wages significantly. Historically, DOL has not been able to say you must compensate those workers because those hours were not, the hours weren't worked. So they weren't able to say you have to pay them. If this rule doesn't get an injunction, then they would have a mechanism for doing so. You must contact the worker in writing using the information that the worker has provided to you. If the worker has provided an email and phone number, you must contact the worker by email and by phone. So by both. And then you must maintain evidence of the notification. So you'll have a form. The form will say, I contacted this worker on this date by phone to notify them that the job has been delayed. I notified them on this date. The start date of the job order was this date. And so you'll do that for all the workers. And then if they gave you an email also, you would need to do that as well. But yeah, you got to notify them and you've got to maintain evidence of it. Okay, so enhanced transportation safety requirements. So this one was already a rule in that you can't take out seatbelts. And I've already seen them enforce it where you have to keep the seatbelts in good working order. So it kind of just codifies that. But seatbelts must meet the U.S. Department of Transportation standards if the vehicle was manufactured with them. Employers are required to keep, so that basically if it was manufactured without seatbelts, it doesn't make you go in retroactively, but employers are required to keep seatbelts in good working order. I think that it would be prudent in your job order to say employee agrees that if they find a seatbelt that is not in good working order, that employee will immediately notify employer of such. And then you would have to go and get the seatbelt fixed. Workers must wear seatbelts before vehicle operation. That's also a good thing to put in your job order. Put in the job order that the worker agrees that he or she will wear the seatbelts provided to them while the vehicles or before the vehicle is in operation. Prohibits anyone from operating employer-provided transportation without providing, maintaining, ensuring the wearing of seatbelts. And then employers do not need to retrofit vehicles that were not required at the time of manufacturing to have seatbelts. Again, I've seen DOL already enforce that one, but they're just putting in this rule so they have another basis to do so. Enhanced transportation for job opportunity. The employer must provide detailed. So this one makes the filing process for H-2A farm labor contractors significantly more difficult. And this is information, if you're someone who's normally gathered information 80 days in advance from your clients, you might want to consider doing it 90 days in advance. But employers must provide detailed information about ownership, operators, and managers, supervisors of H-2A workers. The employer must update and retain required information until the end of the work contract period, including extensions for 3 years, making it available upon request. So you need to maintain this information internally for 3 years. Employer must provide at the time of filing the full. This is the big part. Employer must provide at the time of filing the full name, date of birth, address, telephone number, an extra and in there, and email address for the owners of each employer. So who's the owner of the company? What's their full name, date of birth, address, telephone number, and email address? You have to provide the full name, date of birth, address, telephone number, and email address for any person or entity who is an operator of the place of employment, including the H-2A's FLC, fixed site agricultural clients. So this would require you as an FLC to get the phone number, the full name, date of birth, address, phone number, and email address of the actual farm owner and the general contractor if you are a subcontractor. So you need to provide this information at the time of filing. Any manager or supervisor of the H-2A workers and workers in corresponding employment under the H-2A application. So I think that the ones that are going to be the hardest is that second bullet point there. Any person or entity who's an operator of the places of employment. It's going to be tough to get. So get it well in advance to your filings. Okay, so the single employer test, for those that don't know, that the single employer test has been something that's been used by the Department of Labor for a long time. Uh, there was an ALJ decision that basically said the Department of Labor should not be using the single employer test. Department of Labor still continues to use a single employer test, and they want a legal rationale for doing so. So they are adopting it in this final rule. So it adopts the criteria to assess if normally separate employers are effectively. One, it formalized the Department of Labor's use of single employer test to integrate employer test for assessing compliance. Aims to identify companies falsely claiming to be separate to evade obligations. So basically, what's happened before is someone got debarred, and then they'll start a new company in their wife's name, but nothing changes. Management doesn't change. The workers bringing in doesn't change. The ownership of the tools and equipment, that sort of thing, doesn't change. And they've done this to evade their obligations, whether it is back wage obligations or debarment from the H-2A program. And basically what this does is it says, no, we're going to have a rationale for assessing if you are a single employer. And if you are, then the debarment of the prior employer also debars this subsequent employer as well. And it also streamlines the process for their debarment of that particular employer. Historically, the way they would have had to do that is they would have had to go through a wage and hour audit, determine this was a single employer, issue a debarment and a final determination. Employer then could have appealed that as well. Meanwhile, the prior businesses debarment period is progressing. So effectively, by the time the second one was debarred, the first one wasn't debarred. And so they're trying to basically avoid that. Okay, and then this is what I just talked about. Is it enhances the department's ability to apply orders of debarment against the successors of interest. So it makes it to where you can make both of them liable for each other's debarment. I'm not going to go too much into detail on that, but okay, so this is also an important one. A lot of this you can accomplish by putting it in your job order. So it's important that if you're not now, work with someone who is very detailed in the job order, has a very thorough job order, and is not just saying, here, fill this thing out. That's not going to be good enough. And it's going to have significant implications. So you want to make sure to work with someone who's done this for a long time. That would be one of the questions that I leave and I ask the person that is helping me with these filings. How long have you been doing this? If they have been doing this for 5 years or more, get out of that relationship, because it can get you in trouble, and their debarment processes are going to be significantly easier if this goes into effect. And so any of these new, and I know a lot of really good agencies. I've got friends that are really good agents. I've got friends that are really good agents on this right now, and so this is not related to them. But if you are working with someone who is a newer agent, be very, very careful, because it could significantly jeopardize your ability to participate in the H-2A program in the future, because you need to be working with someone that actually knows these rules, knows the application of them, knows what the Department of Labor is trying to do, and it is going to make a big difference. So employers are required to disclose all productivity standards affecting the job retention. So in your job order, review the job order and think about, this is something that your agent or attorney cannot do for you, and that they don't know what your productivity standards are. They don't know the things that you are determining on if an employee is a good employee or not. Now, a good agent or attorney can actually put it into the job order for you, can review it for you. But they can't draft that for you. So you need to make sure, or that they can, I suppose, could draft it for you, but you're the one that knows your productivity standards. Be sure to disclose in your job order. And then ensure the workers are aware of the terms that could impact termination for cause. So the termination for cause notification, the awareness of the terms and conditions, this is going to be from the ETA 790 that's translated into the worker's native language, and they sign it back in their home country. This is making that process significantly more important. Historically, it's been a slap on the wrist from DOL if you didn't do it. Not anymore. It matters a lot, and so be very careful. Make sure that that's happening. Productivity benchmarks must align with industry norms among non-H2A employers. This just means that you can't have some absurd productivity standards that are not normal in your type of employment. Adjusting the productivity standards mid-contract to terminate, to justify termination is prohibited. Again, this is just emphasis on the importance of the ETA 790. And so any ETA 790 that's filed on or after August 29th, you need to make sure that these are properly disclosed. Job orders must list prevalent piece rates, highest hourly wages, and any intended pay. So be clear in your job order. If these conditions are met, then I will pay this rate, and be consistent with it. You don't want your ETA 790s anymore to just say we might pay more. Be very clear with what that actually looks like. And then the workers are entitled to the highest advertised wage at the work time. And then that means that if you file the job with a particular adverse effective wage rate, but you end up paying all your employees a higher wage rate, any worker that was displaced would be entitled to not just the adverse effective wage rate, but the wage rate that you actually paid your workers. This is kind of how the Department of Labor has applied it historically anyways, but now it's codifying in this rule as well. And then if you have overtime wage rates and conditions for eligibility of overtime, those must be disclosed in the job order. Again, that's something that we always do in our ETA 790s anyways, but it's a good thing. It's now being codified. So it's an important thing to have in your ETA 790. Protections against passports and other immigration document withholding. I always tell our clients, do not hold or confiscate your workers' passports, visas, or other identifying documents. This rule's codifying that from the H-2A standpoint, but there's already laws that prohibit this. So this is just an additional effort by the DOL to make sure that that's not happening. And the reason for it, for those wondering, I actually don't hate that rule. That the reason for it is because employers have done that as a means of controlling their workers. So they'll hold their passports so they can't go home, and they'll hold their passports so they can't leave, that kind of thing. And they've done it to some they've significantly abused workers by doing that before. And so I always just tell our clients, just don't do it. Even and they gave some rationale in the final rule for when you could do it. Don't do it. Just don't do it. I don't care if the worker is requesting you to keep them. The only time that you have them is you get their documents to scan in for document retention purposes. You give them right back. Now, if you are going to go directly against that advice, this is what the Department of Labor says to do. You have to have the worker voluntarily request the employer keep the documents. The worker needs the worker is not directed to submit a request for safekeeping. The documents are returned immediately upon request, and the worker must state in writing that the three conditions above are met. And the worker will have access without meaningful restrictions to their documents. And so if you are going to do it, you need to get in writing that the workers were requesting that you do so. And so But at the end of the day, please just don't do it. Just don't hold their documents, even if they ask you to. Just say, no, those are your documents. I don't want to be. I don't want to hold them. Um. Okay. So and that we're actually doing pretty good here. So side agreements. Employers may not ask workers employed under the HOA program to sign any side agreements relating to their rights under the program. So you can't ask workers to adjust their 3/4 guarantee or outgoing transportation liability. You can't have arbitration agreements with them that aren't disclosed in the job order, as opposed to um, litigation by some plaintiff's lawyer or worker advocacy group or something like that. You can't mandate arbitration with them separately. And then forms that purport to add or waive terms and conditions of employment, you can't bring them up on a job order and then give them an agreement that says, hey, waive all these things in your job order. That's basically all that is. So yeah, any questions that y'all have, just go ahead and put them in the Q&A. I'm going to get to those. If y'all are trying to get a hold of us, you can get on the Farmer Enterprises website right here. You can get on Farmer Law's website, which is farmerlawpc.com. You can call us, email us. Happy to help anyone out. All right, let's get to the Q&A. Okay, so the first question is, what about employers who own several different companies and each file separately? And I'm guessing, feel free to clarify this if I'm not answering the question that you're asking. I just want to make sure. But I'm guessing that this is related to the single employer test. They would view them all as a single employer. So if you file separately, but you still meet the conditions of a single employer, then you would still be viewed as a single employer, even if you have several different companies that file separately. Okay, what if they can't get a consulate appointment prior to the start date of the certification? Is that considered a delay? That was not disclosed in the final rule. So the example here, this is a really good question. The example here is that the certification starts on 9/1, but the consulate appointments are full until 9/15. I would suggest that you still notify them in writing of that. Say, hey, the job's ready for you starting 9/1. The certifications started 9/1, but the consulate appointments aren't available until 9/5, and so it's going to delay your start date until you can get your visa. I think that that's a really good thing to notify workers of. Okay, termination means within the same season, correct? It had no effect on whether you choose to bring the worker back the following season. Yeah, so again, sorry because I know that these were asked as I was going through it. So feel free to put any kind of clarifying question in there if you'd like. But I'm guessing that this is referring to the retaliation portion. There isn't an obligation to bring the same workers back, although your rationale for doing it cannot be their enforcement of their rights as workers. So, and that's been a longstanding rule. The Department of Labor has historically viewed that as retaliation if your only rationale for not continuing to employ them is their enforcement of their worker rights. Okay, so this is I did not mention this, and I'm so glad this question was asked. What if the certification starts on April 1st and we have delays and can't bring the worker until May 15th? Do we have to notify them every 10 business days? No. If it goes beyond 14 days, you have to file a new certification. So that's going to be difficult. It's not about continuing to notify them. It is about filing a new certification if it's delayed more than 14 days. So the question is, so I'm understanding that if I build on 70 different farms, the expectation is I ask my customers for their dates of birth. That's right. That's one of the absurdities of this rule. I should probably mention at this point that I'm going to keep y'all really updated on this rule, because I think that there's a lot of serious issues with this rule. And right now they're seeking, I know it's insane. Right now they're seeking preliminary injunction on this rule. The rationale for it, I think, is strong. And I don't know how many of y'all are familiar with the Chevron doctrine, and then that the Chevron doctrine is recently overturned, but that gave a big breath of life to this and to this pending litigation, to prior litigation. There's still ongoing litigations, for example, with the prior wage rule. And overturning the Chevron doctrine is really important. That happened, I think, 2 or 3 weeks ago now. And what the Chevron doctrine said, it came out, it was a Supreme Court ruling in 1984. And that rule said that courts should give deference to the executive agencies in interpreting the laws of Congress. And so it gave all these executive agencies a tremendous amount of power, because if there was any ambiguity, then they could just make it up. And the courts had to go with whatever they just made up. This was a direct contradiction to the founders' intent in the Constitution. They even write about this in the Federalist Paper 51, where the system was set up so that we have checks and balances. We've got our judiciary, our executive branch, and our legislative branch. And the founders recognized that the legislative branch is going to be the most powerful one, which is why they bifurcated it into the House and the Senate. And what happened with all these regulatory agencies is Congress essentially delegated its authority to the executive branch, which completely made the executive branch, which was expected to be the weakest, to be the strongest of the 3 branches of government. And this went on for the last 40 years. So since 1984, regulatory agencies, including the Department of Labor, including the IRS, including the Department of Justice, you name it, these executive agencies were able to modify their rules such that they could essentially do whatever they want, so long as it wasn't arbitrary and capricious. Now, that's not the case at all. Now it's requiring the courts to actually go back and look at the intent of the legislature at the time of drafting the legislation. So it is important, and it does make me think that this is significantly more likely to get an injunction, which is what I'm hoping for. But as of right now, it's effective August 29th, but not yet. To clarify my earlier question, the ETA form Appendix C is where you list the names of owners, operators, managers, and supervisors. A required field is the FEIN from the IRS. Would the FEIN be for the farm or the person? It would be the business, the farm. If the owner owns multiple entities, can they use the workers in those other entities if the type of work is listed in the contract? You could. So let's say I'm just going to give an example with construction. Let's say that you own 2 construction companies, and one of those construction companies runs H2A workers. One of them, you have a whole bunch of domestic workers in the other one. Whenever you use the domestic workers in the areas of intended employment where you have the H2A application filing, you would still be, because of the single employer test, you would still be required to pay those corresponding U.S. workers the same wages and working conditions of the H2A workers. So you could work them in different companies, but it doesn't really do anything effectively with the single employer test. All right. Do we need to disclose in the job order that some jobs are prevailing wage and could increase their pay for that one particular job? How would you word that? That's a good question. So you would have one job that's a prevailing wage job, and then a whole bunch of jobs that aren't prevailing wage jobs. You would be better off putting it on separate certifications. because the way that the wage rule reads is that you will pay the highest of the prevailing wage determination, or the prevailing wage, the adverse effective wage rate, or whatever wage the employer is intending to pay. And so since the prevailing wage would be the highest of those wages, I could see the Department of Labor saying you need to pay that on all the jobs. So if I were you, I just put it on separate certification so you don't have to do that. Okay. We'll have to file a new labor certification for delayed work, even if the documentation for the project may start after 14 days from the original start date, but before 60 days in the future from the new petition. Yeah, exactly. So I think that that's the big problem with it is I might not know of the start date until a week before the job starts, 2 weeks before the job starts, and it might be a 30-day delay. But now you're telling me I'm going to have to be 2 weeks late to that job because the regulations require that it's 60 to 75 days in advance. I suppose that you could try for an emergency certification in that particular circumstance. I'd be curious to see how the DOL interprets that. But technically, yes. Does listing the owners need to start in August, or can it start with our next contract? It can start for any labor certification that's filed on or after August 29th. Did you interpret the contract address, or the contact address of the owners, managers, supervisors as their home address? No, I didn't. I interpreted it as the employer's address because it is going to be publicly available, and I would not suggest you making you or your supervisors or the farm owners, any of that, making their home address publicly available. If there are any changes in the supervisors, do we need to update that information? It's in the filing documents. It's in a new appendix that they're sending, so there's not really a good way to update it, I suppose. But there's not really harm in updating a new Appendix C and filing that with DOL. I like that idea. This question is back to the prevailing wages. We don't know what the wages will be until we're given the job, usually a month prior to the date of work. We usually do a couple of prevailing wage jobs a year, and each one is a different pay scale. I mean, I don't know if there's any way to get that 60 days in advance or 75 days in advance, but that's what's going to be required to put it on a certification, because the regulations require that the certifications be filed 60 to 75 days in advance. What would be an example of productivity standards that would hold up to the DOL's criteria? I think we would need to dive into your specific type of work to really answer that one effectively. So we can certainly do that, but it's going to be based off of your individual type of work. Oh, someone clarified this for me. Thank you. I guess I missed that as I was reading through the rule, but it says that the procedure for workers' arrivals being late due to embassy appointments doesn't apply to government delays or scheduling delays. So that's great. All right. Okay. So big takeaways here. Step one, get a copy of your job order, review the contents of the job order, re-listen to this so that you can know the things that you need to specify in your job order. And the second one is make sure that the person that is helping you with your H-2A filings is someone who is experienced with these, who knows these types of filings, because I do firmly believe that the Department of Labor, if this rule goes into effect, will be seeking debarment actions for many of the violations of these regulations. And the reason I think that is because they have done that before, because they say that the rationale for debarment is generally when there is substantial harm to the workers, to corresponding workers, or to workers or corresponding workers. And so they're going to use this as a rationale for saying this constitutes substantial harm. We're going to seek debarment action. And so make sure that the person that you're working with has done H-2A, really knows it, and is not someone that just started doing this in the last 3 years. 2 years, because they have not seen over the course of time how the Department of Labor has changed their enforcement actions against employers. They can't help guide you through the ETA 790. So make sure that the people that you are working with are reputable. Again, I've got some good friends on here who we have been doing this for a long time. I do a ton of audits, investigations, appeals. I know these rules. I've got some friends on here that are also agents that know these rules, but there's a lot of newcomers out there who are not familiar with them. They're not good at this. They haven't been through the ringer like we have. And so it's important to make sure that the people that you're working with are the proper people, because I'm not a H2A fearmonger, but they certainly are going to try to use these mechanisms for debarment. And I know how it is in these businesses, and that your business comes to rely on your H2A workers. And I know that you cannot find U.S. workers to perform this work. And so it's very, very important. And I'm not someone that just says that lightly. So it's an important rule. Make sure that you're reviewing your ETA 790, reviewing it with your attorney or agent, get an attorney's opinion as it relates to the interpretation of the rule, and make sure that your job order is consistent with it. Those are the big takeaways. If y'all have any questions, feel free to reach out to us. Really appreciate everyone joining. Thank you.